The Caspian arbitration rules have been defined with really a fresh beginning in mind. There are many problems in litigation and arbitration, but foremost amongst them are people dragging their feet, lack of expedition, and costs. I'm acutely aware that personally I've participated in increasing legal costs over the last 20 years, but there must be a way of resolving disputes fairly and at a reasonably achievable expense. Now, arbitration, is it something new, and what is it? It really is just an informal means of enforcing a right you have under a contract where the parties have chosen to arbitrate rather than to litigate. It's been around for over 400 years, as Cook's case demonstrates, and it has two principal advantages over litigation. The first is enforcement. Enforcing a judgment of a national state court somewhere else in the world where you can find assets is a very tricky procedure. Enforcement of an arbitral award under the New York Convention, almost anywhere in the world, is a straightforward process. There are exceptions, but there aren't many. And the second, and equally important, is confidentiality. Many clients don't want their disputes emblazoned over the press and available for public review. Arbitration is a confidential procedure, and depending on what you agree about appeal, almost completely confidential. And I want to look at the most common, in my experience, contemporary complaints about arbitration to see and then compare and contrast those complaints with what is envisaged in the Caspian rules. The defects with current arbitral regimes: too slow. Anyone who's been involved in an ICSID or a big ICC arbitration will know that this is no overstatement. Big arbitrations can take years and years and years to complete. Too costly, and that's particularly in the smaller disputes, where legal costs can frequently amount to a large percentage of, or sometimes more, than the entire amount at stake. The difficulty in obtaining urgent relief. And I think our current arbitral institutions let us down in this regard. Frequently, it is necessary to obtain a very urgent injunction. If, for example, your opponent is about to dispose of all of his assets, so you can never get your hands on them, there must be a mechanism in arbitration to apply to the courts promptly and in a satisfactory manner to obtain something like a freezing injunction. Toothless sanctions is another problem with arbitration, particularly international arbitration, where you have a mix of cultures, perhaps 3 different nationalities on the arbitral panel. In my experience, they tend to be very reluctant to bring down the guillotine. The next problem is interference by national courts. Most people who arbitrate assume, or at least I think they assume, that the arbitrators will be the final arbiters of most matters. However, increasingly in various jurisdictions, national courts interfere. There are rights of appeal. There's a right of appeal in England if you can show the matter is, as we call it, one of public importance. And I'm not sure in many arbitrations that this is what the parties wanted. The next complaint that I hear a lot of is the individuals actually appointed by arbitral institutions. They frequently are people who the parties have never heard of, often will be of different nationality, and from time to time seem to have no relevant experience to qualify them to resolve the particular dispute in question. And the bigger the arbitral institution, the greater I think that is a problem. And then lastly, the centres of arbitration, certainly in Europe, for commercial arbitration, are London and Paris. and the Caspian rules foresee a greater role for Geneva as a seat of arbitral proceedings. So the aims of the Caspian rule, the first and perhaps the most important, is to resolve disputes quickly, expeditiously. And that's not only, we'll look very briefly at time limits, but by imposing tight time limits, but imposing really very stringent sanctions for the party that simply does nothing. And that has become a huge problem, not only in arbitration, but also in Europe in litigation. A recalcitrant debtor, if you agree with another party that your disputes will be resolved in England and Wales, the other party, who knows he has no defence to your claim, can start an action for negative declaratory relief, a statement that he owes you nothing, in another European jurisdiction. And this is starting to happen, particularly, without singling anyone out, certain Mediterranean jurisdictions that tend to move at a more modest pace than some other jurisdictions. The rules of the Lugano Convention for Switzerland or Brussels recast for the rest of Europe are that the court second seized, which in this case would be England, has to stay its proceedings unless and until the court first seized, the one which never had jurisdiction in the first place, declines jurisdiction. So it is a tool used by recalcitrant debtors to slow things down. You start in a jurisdiction which wasn't the agreed forum, but the agreed forum has to wait under the rules unless and until that other forum declines jurisdiction. And that's something, fortunately, that arbitration doesn't suffer from. There's no obligation on an arbitral tribunal to wait until another state court declines jurisdiction. To determine claims fairly, cost-effectively, provide firm sanctions, and lastly, to limit rights of appeal. And that can be done in a number of ways. Firstly, and commonly, at least in London, you can choose a foreign law and a London seat to ensure that when matters of law are determined, they are found by the arbitrators as matters of fact. And having been found as matters of fact, the right of appeal of both sides is limited. And that is very popular in certain insurance industries because it ensures almost complete confidentiality for those parties that really don't want the details of their dispute dragged before national courts. And that could be done in Switzerland by providing for English law and Geneva seat, or indeed vice versa. Now, turning briefly to the rules themselves, I mean, 7 years is no anomaly, unfortunately, in commercial arbitration for a length of a hearing. And that's particularly so where states are involved or state-owned organisations. They tend to drag their feet at every possible opportunity, and arbitrations can drag on for many, many years. So the principal, or certainly one of the principal objectives of the CAS rules is swift dispute resolution. So once arbitration's been commenced under Article 2, the respondent has only 14 days in which to respond. The statement of case comes in 28 days thereafter. There's then a further 28-day period for each of the following pleadings, but perhaps the unique thing, or the first unique thing about the CAS rules is that the tribunal must, not may, move swiftly to a default award in the event of non-compliance with the time limits for a period of another month. And in practice, that means that the tribunal will order a final award granting all of the claimant's claims except those that are manifestly without merit. That is a very low, or it depends which way you look at it, high threshold. In order to be manifestly without merit, a claim has to be complete moonshine, obviously wrong, etc. So if you have a recalcitrant party a party that simply doesn't want to participate, a debtor that doesn't want to pay, this is a very useful tool in Article 8 of the CAS rules. The second way in which dilatory conduct is prevented under these rules is that the tribunal's power to grant extensions is limited. And those of us who've been in arbitration have seen time and time again an indulgence granted, a period of an extra couple of months. The party who's obtained that then comes back on the last day and says, due to unforeseen circumstances, we need another 6 weeks. The tribunal regretfully grants them another 6 weeks, and at the end of that further extension, the party seeking to delay matters says, well, due to unforeseen circumstances, we need one further final extension, which is usually granted. And tribunals are very willing to find, quote unquote, exceptional circumstances which entitle parties to delay matters. Under the CAS rules, though, the tribunal only has discretion for one extension of up to 28 days. Thereafter, the second extension is up to 21 days, but in exceptional circumstances. And there is a definition of what are and what are not exceptional circumstances. And this hopefully should prevent, or at least assist in the prevention, of parties delaying matters to suit their own commercial aims and frustrating the party which does have a genuine claim from obtaining its money. There is a power to stay in appropriate circumstances and to correct clerical errors to any award made, but only within 14 days, that's the application, rather than the usual 28 days under most other rules. Now, another feature of the CAS rules is to try to distinguish between two types of arbitration. There are arbitrations, I've called them bet the company arbitrations, where legal costs are frankly an aside. Both parties are so determined to fight to the death that, and such a large amount of money might be at stake, that legal costs are not the main issue. But that is not the ordinary case. In ordinary disputes, and the rules as currently drafted take 20 million Swiss francs as the cut-off point, costs are much more important. They can amount to a substantial proportion of the award, and they need to be regulated. And so Article 9 of the CAS rules introduced what's called costs budgeting, which is now a feature of smaller claims in the English commercial court. And that means at an early stage of the proceedings, you have to set out what you think your costs are going to be. And if you go way over those costs, you're very unlikely to recover them, even if you win. If you fail to produce a costs budget, even if you win, you're only going to get, under these rules, 70% of your reasonable costs. So this is a tool for the smaller arbitration, under 20 million Swiss francs, to try to bring legal costs into line with parties' reasonable expectations. Another issue that clients often have with costs is, well, 5 members of my organisation have been working on this matter for the last 4 years, but I can't recover any of their costs. But their management time was spent on this dispute, and so Article 12 provides expressly that costs of in-house counsel are recoverable. And where a party has failed to either submit a costs budget, if it's a losing party, or if its costs exceed those of the winning party, the winning party is entitled to 100% of its costs, and we've taken this really as far as we possibly can to provide a complete indemnity to the winning party. Because many litigants are very, very disappointed. They win, and then they find they only get 60 to 70% of their actual costs awarded to them. But here, a losing party whose costs exceed those of a winning party by a substantial margin will enable the tribunal to give the winning party 100% of its costs, it being presumed that all costs are reasonable unless convincing proof is provided to the contrary. That is about as far as we thought we could possibly take it without offending the indemnity principle. In other words, it is a very favourable provision to the winning party. Dilatory pleadings are an advocate's nightmare and a nightmare from the perspective of costs as well. In my view, ICSID is probably the worst offender in this regard, but frequently you see pleadings that run to hundreds of pages and, worst of all, repeat their arguments sometimes 5 or 6 times. One of the things I was taught as an advocate is that a bad argument never becomes a good argument by repetition, and that is particularly so in a written document. It is nothing short of miserable to read that sort of pleading, as I have often done. So the idea here is to limit, to get people to choose their words carefully and not just throw any random thought into their statements of case. To keep the notice of arbitration and the response to 2,000 words, brevity as well in the subsequent pleadings, and that I think is something that needs to be encouraged throughout not just arbitration but litigation more generally. A huge amount of money is wasted where parties put in massive documents, because then inevitably, however confident the responding party is, he feels that he has to go back at similar length. There's also a settlement procedure introduced in the Caspian rules, loosely based on a settlement mechanism in the English civil procedure rules. And again, where a reasonable offer's been made but refused, and the winning party does better than that offer, the tribunal shall have the power to award the winning party, and again, the same formulation, 100% of its costs, it being presumed, not quite irrebuttably, but in the absence of convincing proof, that all of those costs are reasonable. Again, the aim is to properly compensate a winning party who has behaved reasonably and put in an offer. This is a unique feature of the Caspian rules. What has been done is to both expressly provide for a very broad category of interim orders, paying money regarding disposition of property, preservation of property, provision of security for a claim or counterclaim. But not only that, to provide for 3 separate fora in which the party can seek that relief. The courts of the seat of the arbitration, which might be, for argument's sake, Geneva. The courts in which any relevant property is situated. That could be anywhere in the world, and that is useful because many courts will not interfere with property situated in another jurisdiction. The situs of movable property is particularly important. And lastly, the Commercial Court in London, largely because it has a particular experience of granting urgent injunctions in arbitration cases. Finality. This is returning to a point I mentioned earlier. Should the parties have the right to appeal, particularly on matters of law, where there has been an agreement that it is to be for the arbitrators to decide? And so Article 32 of the CAS rules waives all rights of appeal on matters of law to the extent permissible in the seat of the arbitration. So in England, that would mean you would have no right to appeal under Section 69 on a matter of law, but of course the principles of natural fairness and justice are preserved. You would still be able to argue a serious procedural irregularity or bias or something of that nature. But I suspect, as most of us familiar with arbitration appeals know, those types of appeal almost never succeed. The tribunal will have power to rule on its own jurisdiction, as most arbitrators do, but Article 32 will prevent a judge in a national court substituting his own views for those of the tribunal. Now, boilerplate clauses, standard clauses in contracts, particularly for commercial men, aren't regarded as being very important, but they can make a very big difference to an outcome of a dispute. If you don't bother putting a law and jurisdiction or arbitration clause into your contract, you're entirely dependent on the conflicts of law rules of the particular state court before which the dispute comes. The CAS rules try to encourage the parties to choose both choice of law rules and seat of arbitration, to expressly provide in their contract what the law is to be and where the arbitration is to take place. And do bear in mind when considering this that it is perfectly proper and acceptable to choose a different proper law from the seat of the arbitration. And people frequently do in London. But the clear invitation is to invite the parties to make an express choice. And it still amazes me that in certain types of sophisticated transaction, the parties don't bother putting law and jurisdiction clauses in. Letters of credit is a good example. We have the UCP 600, but nobody generally can be bothered to actually stipulate what the proper law or place of dispute resolution should be. I'll speed up now and apologise, but I was going to take you on a slightly different journey now, just to look at categories of mistakes in commercial contracts. And this is from my own experience largely, and I've labelled the first the tea break. This is where somebody in the middle of drafting something, the typist's eye skips over a section and the clause can become completely unintelligible. And a failure to delete words is another frequent mistake. I'll give you a very quick example. I had to advise on an agency transaction which said that the agent was entitled to 10% of the value of the transaction, or 5 million euros, whichever is greater or less. Which was it? And somebody had obviously failed to strike one out. The lucky dip is the good clause selected by the office tyro, the junior, but for completely the wrong type of transaction. The collage, that is overkill. Far too many clauses, banking contracts are one of the worst offenders for this, are thrown into the contract without any view for mutual consistency or inconsistency. And we've had a string of cases in the English courts with contracts with both jurisdiction clauses and arbitration clauses. The lazy catch-all title, trying to define everything so incredibly broadly to catch everything that you lose any meaning. The palimpsest, we in England are probably pretty bad at that. That is the putting in old verbiage that nobody knows what it means, but it's been there for 300 years. Rovers is a good example, and without historical archaeology, it is meaningless. The ampersand blunderbuss really is the hallmark of the lazy lawyer, and/or. Frequently, it is either and or it is or, it is not both. The false friend is the good clause but in the wrong contract. You've also got designer confusion in certain types of clauses. And probably the worst of all is the blunt instrument. The syntax simply hasn't been worked out well enough. It's sort of good enough for the job, And I'm going to give you a real example from a very high-value reinsurance arbitration. In the event the reinsured being liable in respect of any one loss for any sum in excess of the retention hereunder under any 2 or more years of account, then it's hereby understood and agreed that the amount of retention in respect of such loss shall be reduced to that percentage that the reassured's loss bears to the total amount on net loss in respect of that loss in question. Not entirely straightforward to interpret, and a very great amount of money rested on that, but it is the most common mistake. Sort of does the job with a wet towel on head. And lastly, and in conclusion, if you do have to arbitrate and you feel that the person that you are in dispute with is unreasonable and unlikely to facilitate any form of settlement, then it is a tightly controlled scheme of arbitration, little prospect for outside interference, and a great deal of party autonomy in terms of choice of proper law, etc. Thank you. I don't know if anyone has any brief questions or... Please.
Hi, Pavan Dugal, Advocate, Supreme Court of India. You said this society is going to be launched today. There's a launch event later today evening.
I think the launch date is actually this evening, or in the very near future. But my colleague would be able to give you the precise date.
What is the mechanism of being enrolled and empaneled as an arbitrator with the CAS?
Appointment to the panel of... I think that's currently being organised by one of my colleagues here, but I think the CAS is in process looking for suitable arbitrators, so it's underway now.
More questions? So,
just out of curiosity, when you have conflicting clauses, like one paragraph says one thing and in another one you have, I'm not going to say completely the opposite, but something substantially different, which one prevails?
Well, I don't want to do any disservice to the judge sitting next to you, but I do think, particularly the English courts are very guilty of this. They strain every sinew to find that the two clauses are, in fact, consistent. So when, for example, you have an arbitration clause and an exclusive jurisdiction clause in the same contract, the honest answer might be, well, they are inconsistent. But what the courts tend to say is, oh, well, what the parties must have meant is that the actual dispute was supposed to be resolved in arbitration, but when you get to enforcement, certain courts had jurisdiction. And there's a lot of that fudging that goes on. I mean, sometimes it's simply impossible. You have to look at it on a case-by-case basis. But the unwritten rule is the court will strain every sinew to find that apparently inconsistent clauses can work together.
thank you so much. Thank you so much. Monsieur Blackwood, thank you.